There is a bill that is being discussed in the state assembly that has drawn fire from the Los Angeles County Deputy District Attorney. We got Michele Hanisee on, who's going to discuss this bill and talk about a possible diversion plan for those individuals who may have committed a crime but have a mental illness. Michele Hanisee, thank you very much. You're president of the Association of the L.A. Deputy District Attorneys. Tell us about this bill and where you and your organization stands as far as pro or con.
Well, it's a little late to take a stand against it because the legislature already snuck it through, passed it, and the governor signed it. It is now the law. It got hidden. This radical vehicle, this legislative experiment got hidden in a healthcare budget trailer bill. So it is now the law. And what it does is it allows a court to give diversion, which means divert them from criminal proceedings for anyone who has a mental illness where it is proved that the crime was related to that mental illness. And the problem is not that it gives people with true mental illness a chance for diversion. It's the manner in which this was done and the lack of checks and balances that the law is written.
Well, let me ask you, I've read the article and the storyline on the bill, and it gives the ultimate decision to the judge. And my question to you as president of the association, do you have confidence in the trial judge to make a determination as to whether or not the mental illness component played that aspect and whether or not a diversion should be appropriate? The question is, the judge makes the final decision. Your response to that?
Well, my response to that is I do trust the judges of this county and other counties. The vast majority of them are very smart, very reasoned people. The problem is even judges need good information to make good decisions. And this only gives the defense the right to present a report or information about the mental illness. The prosecution has no right to present a report. There's nothing in here about victims having any input at all. And it very broadly defines who is eligible and places limitations on the findings the judge can make to determine ineligibility.
Well, let me just, and we're talking to Michele Hanisee, who's the president of the Association of the L.A. Deputy District Attorneys. Here's my question. There are, and I think you would agree, thousands of people in our prison system that suffer from a mental illness, that an issue such as a mental illness that was not considered an issue when it came to the process of the trial and the subsequent conviction. And my question here is, do you find this bill or this law overreaching, or you feel that it doesn't have enough check and balances because of the acknowledged fact that there are many people who are incarcerated with a mental illness?
Correct. Yeah. The thing is, the bill is overreaching in the way it was enacted was frankly really shady. There was a legitimate bill called SB 215 that was also diversion for people with mental disorders that was being openly debated in the legislature, as a bill should be, to make sure the language is appropriate. It had checks and balances. It had some limitations on judicial discretion, and it allowed the prosecution to have some input in the decision. This one took out every single check and balance and then snuck it in a trailer bill so no one would know what was going on and didn't even have a chance to discuss it. So the process by which it was enacted alone is objectionable. And the fact that the prosecution is basically allowed to stand there and watch and do little more, and the opinion of the prosecution doesn't even have to be considered. If someone has a legitimate mental illness and that was the cause for their committing a crime, that is certainly worthy of consideration. The problem here is, how do you test whether they have a legitimate mental illness and that was a result of the crime when only one side gets to present information?
Well, I think you have a legitimate argument if the prosecution is unable to provide a counterbalance to the medical report provided by the defense. It does it not preclude you from suggesting to the judge that more evidence is necessary before a decision is made? It doesn't preclude you from providing information that would, non-medical information that would counteract the fact that the cause of the crime was not related to mental illness. You do still have tools at your disposal.
Well, we're not going to lie down and say nothing. And of course, if we think it's inappropriate, we will argue that. But the law says the judge may consider the opinion of the district attorney. That's not even mandatory. They actually cannot consider our opinion. And if we were doing this at a trial and someone were presenting a mental defense, we would get to know what the defendant said to the defense expert. We would get to cross-examine the defense expert. We would be allowed to see the results of any psychological examinations given to the defense, and we would be allowed to have our own expert do the same testing. So those are the checks and balances that exist in the normal course of the criminal justice system, and they're completely removed here, as is any right of the victim to be heard or to obtain restitution.
No, let me tell you right now, being a lawyer myself, I think there has to be a fair balance of information exchange, and it seems to me that the district attorney is being handcuffed in being able to provide an alternative argument to a suggestion of a diversion plan. Let me ask you the question: has there been any cases that have come to the pipe, or has this law gone into effect yet? I mean, you said it has passed. Has there been an effective date yet?
I actually don't know the effective date. It might be the beginning of the year, or it may have gone into effect. I believe this one went into effect immediately. So it's in effect now, but it's been in effect for a matter of days. Mm-hmm. So I don't think we're going to see anyone using this for a little while yet, although with the leniency of it, I expect the defense to take full advantage, because they're allowed to consider anything in it's called the DSM, the Diagnostic and Statistic Manual of Mental Illnesses. Mm-hmm. And the DSM defines all kinds of things as mental illness that it would be criminal conduct, pyromania, kleptomania, alcohol intoxication, drug intoxication, even caffeine intoxication is defined as a potential mental illness. And then there are things that give you serious pause, like male hypoactive sexual desire disorder, which is a persistent deviant sexual thoughts and fantasies and desire for sexual activity. Well, if that person's going around raping someone as a result of that, quote, mental illness, is that someone who we want to absolve from criminal liability?
No, we don't. And I can see the concern. I can hear the concern in your voice. And it seems to me that what's going to be very interesting to find now are cases that come through after this, some cases that will test the validity and the strength of this case and the role of the judge. And on behalf of all of us here at Talk Radio 790 KBC, we want to thank you for presenting this issue to our KBC listeners, and thank you for joining us.
My pleasure.